Good afternoon, everyone. Welcome back to In the Office with Scott and Wallace. We're here with can't retake that.
No, it's fine. It's fine.
No, we're here with you every Tuesday at 2 p.m. And as long as I can talk, we'll get through this. But today we're going to do something a little different. Clint and I are going to throw some hypotheticals at Matt regarding some of his practice areas and the issue. I should say the issues that you run into in your practice areas, which of course are employment law and workers' compensation.
Some of these are based off actual calls, similar calls
Yeah.
we've had from people, or cases that we've read about.
Yeah, so today we're going to, focus more on employment law issues. And so we'll treat it more like a lightning round, and we'll throw some things at you and then see what your take is. All right. So I'll start it, and then we'll let Clint do one. Let's do four, and then we'll get on with this.
You're like 30 seconds on the clock.
Yeah,
no whammies, stop.
Yeah, that's right. And if we need to go into overtime, like the basketball game last night.
All right.
Okay.
I like it.
So here's a hypothetical. So we've got a woman working under a male supervisor in a business that has 5 total employees, and the male supervisor is sending her sexually explicit images to her computer as emails routinely. Let's say it happens 10 or 12 times a day.
Mm-hmm.
He's also making comments that involve sexual innuendos, and he even sent her an email saying that he would really like to take her out on a date and hopes that given their relationship and her future, her goals of being promoted within the business, that she would take him up on that offer.
It's the boss of the year, huh?
Yeah. So 5 total employees, and she works under a male supervisor. Can she bring a sexual harassment claim?
Well, as far as specifically addressing the ability to bring a claim, unfortunately, both state and federal law, when they prohibit discrimination for employers, they define employers to mean companies that have 15 or more employees. So it doesn't count independent contractors, necessarily doesn't count even the CEOs and the other higher-ups of a company. So as ludicrous as it sounds that sexual harassment can occur in smaller businesses, the laws that we would proceed under to bring a sexual harassment claim only apply to businesses of 15 or more employees. So as egregious as that conduct is, and she certainly should complain about it and not put up with it, as far as a sexual harassment claim goes, she would be unable to bring one.
It's pretty amazing, isn't it?
People are always shocked when I have to go over that with them, because that's one of the first questions I ask when I talk on the phone with somebody is how many employees are there? And they kind of just brush it off, and it's unfortunately an important question.
So jurisdictional requirements are very important.
Yes, 15 or more employees, so larger businesses.
Okay.
Yeah, it's pretty.
Yeah.
Wow.
Pretty crazy. All right.
Okay. How about this one? This is based on a case that I read about. Lady's pregnant, high-risk pregnancy, and the doctor tells her that she needs to go on bed rest before she has the baby. Tells her boss says, we don't have a position for you to do that. You can't take off bed rest. If you can't work, then you're fired. How would that play out?
So under Florida law, we've talked about how Florida law and federal law are almost identical as far as the discrimination that they prohibit. It's almost a copy and paste. But Florida, we actually specifically include pregnancy as a protected class, basically a characteristic that you cannot make business decisions based on. Okay. So similar to an individual who has a disability, an employer would need to make a reasonable accommodation in that requirement. And the courts often say that a limited time off of work, obviously you can't take 6-9 months off in a row, but if limited time off of work is a reasonable accommodation, they need to go through the process of attempting to at least accommodate her pregnancy. And if they weren't going to accommodate her pregnancy, then it'd be the same thing as telling somebody who has a disability that, oh, because of your disability, we're going to fire you because we don't want to have to figure out how to accommodate it.
Okay.
So under Florida law, it's specifically prohibited to make business decisions based on pregnancy. And similar, because pregnancy only is a female issue, it also leads to gender discrimination claims as well. So the Florida Supreme Court's determined that pregnancy is a female issue, so therefore also you'd be violating that same statute under the guise of gender discrimination.
Question for you real quick, Matt. She says, so an employer though could decide if they wanted to not pay the employee though, right? If they had to go on bed rest, that would be the business owner's decision, or?
It all depends on kind of what the terms of employment are. So common, what they might be referring to, what happens often, is FMLA, which we've talked about, the Family Medical Leave Act. If you're on the Family Medical Leave Act, which applies to employers of 50 or more employees, and you've been working there for over a year, that is a job protection, but it's an unpaid job protection. So if you're going to be out on FMLA, then there is no guarantee, there's no requirement that they pay you. If you're a salaried employee and other employees get paid when they're taking time off, then there's a good argument that you should also be entitled to have the same benefits. Essentially, the employer can't treat the pregnant individual different than they would treat any other individual who needed to take off time.
Okay.
Right.
Okay.
All right. Well, I'm
Next
gonna piggyback on my
Okay.
last hypothetical regarding sexual harassment. Let's make a few tweaks.
Okay.
Okay. Now instead of 5 employees, okay, there's 25 employees. Okay. And the same conduct, you've got a female employee and a male supervisor, and it's the same egregious conduct we just talked about. However, here's the caveat. This female employee is routinely late for 3 weeks straight. But, and give you more fact, during the same time period, one of her male colleagues is late almost the same amount of time. She gets fired after making a complaint about the sexual harassment. He doesn't. Claim or no claim?
We're going to go claim there. So in those instances, the way that these claims work for discrimination is you have to make out your case, then the ball gets passed to the employer, then they get to offer a non-discriminatory, non-retaliatory reason for firing you. Then the ball gets passed to us to show that that is pretext for discrimination or retaliation. Essentially, you have to show why that is inconsistent or unbelievable, or there are weaknesses in applying that logic. So in that situation, the employer would say, I didn't fire her because she complained about the sexual harassment. I fired her because she was late. Then it would go to us to say, well, let's take a look at that. Somebody else who's in that same, is late just like her, engaging in the same conduct, but they're not disciplined the same way she is. And the court would say, well, what's their difference? Well, one was sexually harassed and made a complaint. One was not sexually harassed and did not make a complaint, and that individual didn't get fired, this one did. And in those instances, court look at that individual and say, that's probably pretext for discrimination given the way that they were treated differently. So there are instances where somebody probably could be fired by their employer for the conduct they've engaged in, but if the employer is treating other people differently than they're treating that one, so they're taking that time and taking advantage of that fact to fire you, then it can still be established they're doing it as a discriminatory reason if they're not doing that to other employees.
Right.
If that makes sense.
Yeah.
No, that makes perfect sense. Pretext, yeah.
A common one we get when people call, and this is more not a specific hypothetical, just overtime hours. When is an employer required to pay an employee overtime?
So there's a lot of, under the Fair Labor Standard Act, there's exempt employees from overtime. You probably think of high salary managers, administrative assistants, people like that. But just your general hourly worker who's taking orders from somebody else and doesn't have control over other employees. They are generally included in the overtime category of employees. So if you're non-exempt, then you're entitled to overtime for any hour over 40 hours you work in a 7-day period, in a 1-week period.
Okay.
Now they can split it up as long as you're not double counting, but if in the course of the 7-day period they're counting for you, once you hit hour number 41, you're due time and a half. And some employers, you can pay more, but you can never pay less. That's established by federal law. Once you hit 41 hours, you're getting paid.
And lots of times we get calls from people who it's a gray area where there might be a manager or not a manager. And so if you have a question about that, call Matt and he can explain and work through some of the intricacies of that we can't explain in a 1 minute.
Exactly. There's a lot of exemptions and a lot of factors that go into that. But the general rule of thumb is if you're salaried and you're taking directions from somebody else, then you should probably assume that you're an hourly and entitled to overtime.
Okay.
But again, yes, please give us a call because they're very fact specific.
Okay.
Well, those are the hypotheticals we had for Matt today. Matt, you need to.
All right.
Any-
Yeah.
Need a breather.
Okay.
Congratulations are in order. We had our NCAA basketball bracket. Robert's wife actually took the cheese with the Virginia pick. Matt finished second with the Virginia pick. And my 7-year-old son Reynolds finished third without a Virginia pick, but he doubled his net worth with a one go. That's good.
Well, are there any questions we need to address, Megan?
No, you got people watching the question. Yeah, you did a great job answering that.
Thank you.
All right, well, my tongue is out of a knot now, and
All
so
right.
I can conclude the show today, or segment, and we appreciate everybody watching, and if you have any questions, as always, don't hesitate to contact us at any of our office locations or online through our website. We're always happy to discuss any issues that may arise, and if we can't help you, we can probably get you to the person who can. So with that, we'll see everybody next week at 2 p.m. next Tuesday.
All right. Thanks, guys. Good
See you
work.
guys.